Welcome back to Rory's Playbook. No surprises, no deductibles. In today's episode, we're lifting the lid on something that's been quietly draining small businesses for years: employment lawsuits, what they cost, how they start, and how they're nearly always rooted in some form of HR decision. And here's the kicker: most of these claims don't come from bad people doing bad things. They come from HR mistakes. But here's the twist: HR is no longer just HR. Who would be surprised if I said that at Lomond Legal they believe HR and employment law are now the same thing? Yes, the same thing. Because in 2025, every HR decision is a legal decision. That write-up? A legal document. That awkward chat about performance? That's legal evidence. Every policy you write, every meeting you have, every warning or termination, it's all discoverable in court. So the question isn't just, is this good HR? It's, can this hold up legally if challenged? Remember, every HR file tells a story, and so it's important to make sure that the story being told is the right one. And that's why Rory exists. We're not just a helpline, we're not just HR. We're legal experts, walking with you in real time, helping you avoid the hidden traps that turn everyday issues into lawsuits. Did you know that 1 in 5 small businesses will face an employment claim? Defending a claim, win or lose, can cost between $125,000 to $250,000, and that's before you factor in time, stress, and damage to your brand. But let's stop pretending employment law is something you only worry about once you're sued. Let's talk about what real protection looks like and why most businesses don't have it. Joining me now is Julie, founder of Lomond Legal, and the reason I exist. Julie believes that employment law support for employers is less than satisfactory. She says it is kind of like saying the system is broken or requires fixing. Before we consider such a perspective, tell us a little about yourself, Julie. How did you get here?
Hi, Rory, and hello to all our listeners. I'm Julie, and yes, that's an accent you hear. Scottish, to be exact, though I now call the US home. My background is in HR, but I've spent the last 2 decades where HR meets employment law. I started my first business in the UK almost 20 years ago. And well, honestly, it wasn't a smooth ride, and if there was a mistake to be made, I probably made it. But I learned fast. I didn't come from a legal background, but when I stepped into it, I found something I loved. I realized this was where I belonged. And I also realized something else. HR isn't just about processes or people behaviors. It's not just empathy or policy writing. It's a balancing act, a tightrope. Because every HR decision now carries legal weight. Most employers genuinely try to do the right thing, but sometimes they get it wrong. And what frustrated me was how harshly they were treated when those mistakes were honest. That sense of injustice made me want to be involved in. That's what led me into litigation. And I've now been doing it for 17 years. There is no claim from me that I am one of the best, because I don't believe there is such a thing. Every case is unique, grounded in its own facts, and each one is a learning experience. We don't live in a perfect world, and hindsight always reveals ways something could have been clearer, fairer, or done differently. What I do know is that I take every case personally. I fight for my clients like it's my business, my reputation, my liability on the line. I don't just show up for the tough times, I help build the foundations too. We're there in the moments that matter most, and we do it exceptionally well. That's also why I built our proprietary digital software as a service platform. Born from this journey, it was created to bring litigation into the modern world, making it faster, sharper, and more efficient. It's an acronym called REEA, stands for Relevant, Intelligent, and Accurate. And that's exactly what it gives us, the confidence that our defense is right. Now we've brought REEA Law to the US, and we're just getting started. Here's what I've noticed. In the UK, employment law is less literal. It's messier and more focused on that term, reasonableness. In the US, things are more standardized, more structured, and very literal. But I see that starting to change. I see the grey areas creeping in. And so, Lomond Legal brings a bit of global expertise, a different lens. We've lived through the shifts I think are coming here, and we've built a model that's ready for it. More than anything, though, I genuinely believe employers in the US are being let down. There are too many gaps in support, and too many moments where businesses are left to fend for themselves. Current models are not primarily designed to help employers. It's a business model and designed to help themselves. Legal insurance, PEOs, traditional attorneys. The traditional models are designed to be reactive in that they show up after the damage is done, or their value is only recognized when the crisis is live and full-blown. Let me give you an example. A business signs up with a PEO and thinks they're covered. Then a discrimination claim lands. The PEO says, "That's legal, not compliance. You need to engage your own counsel to represent you, and we will appoint counsel to represent ourselves." Or that employer with EPLI insurance calls their insurance provider. The insurer says, "We cover this. Just pay your $25,000 deductible and we'll get started." Suddenly, that business has two bad options. 1. Pay a deductible. 2. Pay a traditional attorney by the hour. Either way, they're out of pocket before any real help begins. It's not about pointing fingers. It's just not good enough. And that's why we're here, to offer something better. Julie, when you moved into litigation, what did you learn that shaped the way you work now? Honestly, that judgments are gold. When you really read a judge's reasoning, the way they explain why they ruled a certain way, it teaches you everything you need to know. I started using those judgments as a mirror. We look at every tribunal decision and ask, did our paperwork hold up? Did a policy wording help or hurt us? Did a judge highlight a line we wrote in a handbook or a contract? If something was unclear in court, we fix it. If a judge sides with us based on strong wording, we embed that wording everywhere. This is what we call the foundations, getting employer contracts, policies, and processes built to withstand legal challenge. But good paperwork isn't enough on its own. Middle support is where training comes in, because policies only work when people know how to apply them. We run live training sessions, on-site or online, tailored to employer teams. From line managers to senior executives, we build confidence in applying policies consistently and fairly. We provide refresher sessions, interactive workshops, and on-demand content, all focused on one goal: reducing employer legal risk by upskilling their people. Because the truth is, most lawsuits don't come from bad intent. They come from someone applying a policy the wrong way. And if despite all that things do go legal, we're still there. Clients don't get handed off. Clients don't get a separate bill. We are the ones in court with and for our clients handling the defense, because we've been with there from the start. And we don't just litigate, we litigate smart. We use our own in-house platform, REEA Law, a proprietary digital automation system that we also license to attorney firms across the US. REEA stands for Relevant, Intelligent, and Accurate, and it allows us to handle litigation faster, sharper, and more efficiently. It shortens case law research, tracks case development, and ensures consistency all the way through to the defense strategy. We don't just advise, we don't just train, we build, support, and defend. That's end-to-end protection. That's Lomond Legal. We built something different. No hourly fees, no deductibles, no hidden costs. One fixed monthly fee, unlimited access to legal support, real-time guidance, and full representation in lawsuits. Unlike PEOs, we don't disappear. Unlike insurers, we don't make clients pay to activate support. And unlike traditional attorneys, we won't send an unpredictable invoice every time they pick up the phone.
So if you're running a business and you want something better, welcome. You have found your people. Okay, listeners, if you are making decisions, make them with confidence. Make them with Rory. And there you have it. If you are an employer and you're ready to protect your business before it costs you everything, let's talk. Visit lomondlegal.com to learn more, or book a call directly with Julie. Employment law doesn't have to be a surprise, and it definitely doesn't have to be a gamble. Thanks for listening to Rory's Playbook. Next time, we'll be digging into the real risks behind performance plans and how to avoid turning HR strategy into a legal landmine.